Excuse me, Judge, can you put us in a breakout room?
I most certainly will. You know how to rename that, renamer Ann Holland, please?
Yes, ma'am.
Mhm. Mhm. You have the breakout rooms open? Oh, it can be the number 10, number 11, number 12, number 9. And Miss Deputy, it's so much easier if we go ahead and get that renamed. Hang on a second. Let me rename it.
What is your name, ma'am?
Ann, A-N-N-E. Last name Holland, H-O-L-L-A-N.
Okay. And Holland, yes. It's okay, I got it, Deputy. Okay, you should have, okay. All righty, Attorney Amos,
Yes, Your Honor.
good afternoon, sir. You
Good
have two cases, sir. We're going to take up on the matter of 00860.
Yes, Your Honor.
All righty, let's get on record and court's going to call cause number 2022 CV 00860 in the matter of SA 11 Park owner LLC et al. Plaintiff versus Suwannee. That's Z as in Zulu, W as in whiskey, A, N as in November, N as in November, Y as in Yankee. Barrios, that's B as in Bravo, E, R-R-I-O-S as in Sierra, et al. Defendant. Counsel, parties, please approach and identify who's before the court, starting with the plaintiff.
Yes, Your Honor. Duke Amos on behalf of the plaintiff in this particular matter. SA 11 Park owner LLC et al.
All right, and on the other side, this Vani Barrios, have they been, Zvani Barrios? Counsel is the defendant pro se,
Yes, Your Honor.
and have they been contacted?
Your Honor, so we attempted to reach them, Your Honor, and were unable to reach them. We also sent out notices via certified and first-class mail.
Have they been contacted today?
No, Your Honor, I haven't been able to reach either one of them, Your Honor. They haven't picked up the phone. And I haven't,
Sir.
I'm sorry, Your Honor.
When you say either one, in this case, Svani Barrios, have you been able to get a hold of the named and then I understand this at all. Have you attempted to contact them today to remind them of the court?
Yes, Your Honor. So we did attempt to contact them, but we haven't been able to reach them, Your Honor. And I haven't got a reply back either. That was earlier this morning, Your Honor.
And the matter was reset for 1:30, of which you agreed to. Did you attempt to contact them before logging back on to see if they received your message or they changed?
No, Your Honor, I have not attempted to reach out to them again since the docket that took place this morning.
Okay, since the time was changed and agreed with you, I'll give you an opportunity to try to reach out to them, okay?
Okay, That works, Your Honor.
Deputy, thanks, Deputy.
So, Your Honor, I was able to make contact with the defendant just now. And it appears that although it shows that she received the tracking, apparently she did not check her mail. And so she was not aware of today's setting.
Is she logging on?
I was gonna give her the login, Your Honor, but what I wanted to see is to give her some time, Your Honor. Do you think that it would be better for us to reset this case to next week?
Sure. She needs to go ahead and log on, please.
Okay, let me see if I could get with her and tell her what the login details are.
Okay, thank you.
Okay. meeting ID will allow you to be able to access the hearing. Your Honor, she's downloading the app and logging in right now.
Thank you, counsel.
Yes. And Your Honor, I don't even see my witness in here, so I may have to reset it either way.
Okay. Counsel, did you, while we're waiting for Barrios to connect or not connect, I assume that's probably her trying to connect.
Yes, Your Honor.
I'll make that assumption for right now. While we're waiting for that, did you want to address your other case so that we can keep to a time frame?
Yes, Your Honor. So on that one as well, I'd like to see if I can get a reset to next week. My witness was unable to make it at the 1:30.
Oh, okay. And for both your cases?
Yes, Your Honor, for both of them, if we can get, I don't know what happened to them. I let them know about the settings, but one of them told me she had a doctor's appointment and the other one just hasn't appeared.
Okay, it seems that we have a connection with whoever is at iPhone. On the iPhone, please rename yourself to show your first name and last name. Person who just connected on iPhone.
Zwani Barrios?
Yes, d- can we get a video? And also, can you rename yourself?
Yeah, sorry.
Do you
Sorry,
know
I'm
how
adult. I had no idea that this was going on. Zwani Barrios.
Okay, yeah, I need for you to place your device on a flat surface and place yourself in the center of it,
Okay.
alrighty? And make sure you're in good light.
Okay, let me turn the light on. I'm sorry about that.
Alrighty. Do you know how to rename yourself?
I'm sorry?
Do you know how to rename yourself? You see, if you look at yourself, you see you're logged in as, your name is displayed as iPhone. When you were logging in, it asks you to put your name in there,
Yes,
okay?
I'm trying to.
So click on the three dots to your right, above your head, around your frame, and select rename to rename yourself. And put your name in there, your first name and last name.
Okay.
Marina, Miss Luna,
Yes, Judge.
could you please come to the court?
Yes,
Please
coming.
ask you. Thank you.
Sorry, I can't figure out how to rename it. There we go. I found it.
Could you do me a favor?
Uh-huh.
I asked this person to come back at 2:00. Could you see if they can make it about 2:30 or 3?
What did you ask?
The attorney.
Okay.
If you could call both parties, and I forgot to get their phone numbers. I do apologize. So see if they can come back at 2:30 or 2.
Who are the two parties calling the mistress?
Let me see. Oh, here it is. That's the 2 parties. But let me. That's her number.
Who's her? The attorney, the
Amanda.
attorney?
Yeah.
Okay.
Amanda, and then ask her to contact Mr. Corbin.
Which is
Okay.
the other attorney on the case?
Is the defendant. Yes,
So just the
Yeah.
attorney and the defendant.
yeah, and the other side. Right? Yes, Mr. Coleman is on one side, and she is representing that side. She's representing the plaintiff. I'm trying to find the movie. Here's his number. No. That's your plan. Yes, just have her call Stephen Coleman, okay? Once you get a hold of her, once you get a hold of her, have her let me know.
Okay, and what do
2:30
you,
or 3 o'clock.
so 2:30 or 3?
Yeah, tell them when I'm which one works best for them. Yeah. Alrighty, thank you, Ms. Barrios. Oh, as a matter of fact, Ms. Castillo, I was just instructing my court coordinator to give you a call back, give you and your attorney a call to see if you guys can come about 2:30 or 3. See which one works best for your attorney, and please notify Mr. Coleman. We're running a little bit behind, okay?
Yes, ma'am. Yes, Your Honor.
No, Ms. Barrios. I'm talking to Ms. Castillo.
Oh, sorry.
Mhm.
Yes, ma'am, I would get in touch with them, so tell them about 2:30,
Or 3 o'clock.
3 o'clock. Okay, I will call my,
Right. Probably 3 o'clock works best.
okay, so 3 o'clock. Yes, ma'am, I will let them know.
Thank you so much.
Um.
Okay, Attorney Amos,
Yes,
how
Your
do you
Honor.
say it? Is it Amos, Amos,
It's Amos. Amos.
Amos? Thank you,
Yes, Your
sir.
Honor.
Okay, so you wish to go ahead and reset this matter? Ms.
Yes, sir.
Barrios, do you have a pen and paper in front of you? You are in court. This matter, okay? You have your calendar?
Yes, ma'am. Let me go ahead and get one real quick.
And counsel, afterwards, I can go ahead and, did you guys want to confer and decide on a date that's best for you? The court is not available next week.
Okay.
So we can go ahead and make it the week after, and a Wednesday would be best.
Okay. I could do Wednesday, Your Honor.
I appreciate that.
I'm ready, Your Honor.
Thanks. Let me go ahead and, counsel, why don't I put you in the breakout room with my court coordinator, Ms.
Okay.
Marina Luna.
Okay.
You guys decide on a date and you decide and let her know how much time you need. And then that gives you an opportunity to kind of talk with Ms. Barrios a little bit. She just indicated a bit of a surprise that she doesn't know that this is going on. So perhaps you can not advise her, but let her know what the proceedings is about and the documents that she should be looking for.
Yes, Your Honor. I could do that.
I appreciate it, counsel. Okay, you should have received an invitation, Ms. Barrios. Join Mr. Amos accept the invitation, so you guys can determine the date. All right. Okay, all righty. Ms. Holland, 2 seconds. Gerard Raymond, are you here for a civil matter?
No, Your Honor.
Okay. Who's your attorney?
Attorney Alan Brown?
Alrighty, so we're waiting for him to check in.
Yes, Your Honor.
Alrighty, very good. Alrighty, thank you. If you can reposition yourself, that would be great when I have that done. All right, so I need for you to place your device on a flat surface and yourself in the center of it, okay? And
Yes, Your Honor.
let your attorney know that you're here.
Yes, Your Honor.
Attorney Rodriguez, are you here for Mr. Raymond?
Yes, Your Honor.
Okay. You sound a little far away, so.
Is that better?
uh, That sounds a little bit better. Counsel, can you please have, thank you so much. I need this case file. Counsel, what is the case number?
It is 672803.
Jared is the first name. Alrighty, we're grabbing that file, okay?
Okay.
And counsel, are you here regarding the deployment issue?
Yes, Your Honor.
Okay, we're expecting someone else?
I'm not sure. I believe our office sent some information to the coordinator regarding Mr. Raymond's supervising officer, I believe.
Okay, she's grabbing the file right now, so. Do you want to go ahead and call her? Talk to her?
Talk to your coordinator?
Right, about the documents you sent?
Okay, sure.
Okay. You want me to place you in the breakout room with her, sir?
Oh,
Or you
that would be
wanna-
great. Thank you.
Okay. Oh, yeah. Mhm.
For Mr. Duke, you set him up for the 27th of July.
The 3rd of August. Because we don't have.
Yeah, because you're not gonna make, he said July 27th.
Okay, yeah, no, it should be the 3rd of July.
3rd of July? In the
Yes.
afternoon?
That, or late morning. It's on Wednesday.
Yes, but remember Thursday's docket for next week is going to move to Wednesday.
Ah.
Do you want to do it that Tuesday that you come back?
Sure.
We have like 15 cases on docket, so you can do it in the afternoon.
That's why I
Before the
sent them to you.
PRH, before the performance review hearings?
That's why I sent them to you.
Okay, 2. I'll send them out for 2.
Okay, or any other day that you see fit that they, okay?
Okay,
All right.
thank you.
Um, Officer Lopez,
Yes, Judge.
you're here for,
I got an email stating I was supposed to attend today for a motion for travel. Did you still need me or
right, but for what defendant?
for Jared Raymond?
Okay, all righty, thank you. Waiting on the attorney. But we're waiting on the attorney. I got the file. So. Mhm. Attorney Lauren. Just
Lauren,
give me-
yes, Your Honor.
Say it, please.
Lauren,
Lauren.
that's perfect.
Am I putting too much emphasis on the lay or
No?
no? Okay, all right. So just give me a few minutes so that I will just be able to go ahead and take care of this criminal matter, okay?
Certainly, Your Honor.
Thank you. Hey, counsel, I didn't know what was going on. I have the file, have the court file up here.
I had been waiting for the coordinator to join the meeting, but she never did.
Yeah, yes, she was out here. So that's was my concern. So I just wanted to, I have the court file, sir.
Okay.
Is there anything outside of what's in the court file? I have several motions, discovery motions that you have filed. Outside of that, is there anything that needs to be, that you sent that I need to consider?
Well,
Or
there
you need to find?
should have been a motion for continuance in there. Mr. Raymond is supposed to be deployed. And we sent a motion for continuance, and that's why this was set today.
Okay. State, 88 Boses, are you there?
Yes, I'm here.
Okay, great.
And in the motion, there should be the orders.
State, the cause number is 672803. 672803.
Okay, I have that one pulled up now.
You electronically filed that motion for continuance, right, counsel?
Yes, on July 20th.
Yeah, I have the file. I just need the motion for continuance. 803. Let's get a record of cause number. They're going to bring me out the actual motion for continuance, counsel, but in the meantime, you can walk me through it. Let's get on record. And State, do you have the motion for continuance?
It was probably served on us, but I don't have it in front of me right now.
Okay.
Let me email it to you, Brett.
Okay.
Just give me 2 seconds. All right, it's sent your way.
Okay, thank you.
I don't see anything to be finished.
Defense, that motion for continuance, how did you provide it to the court?
E-file. And I believe it was sent by my paralegal to Marina. But if that didn't happen, I can,
Envelope number.
Do you have an envelope number regarding the e-filing?
I don't because my paralegal does that for me. Let me email it to Marina.
No, sir. She doesn't receive those motions. Motions are sent to the clerks so they can put it in the file
Mhm.
per e-filing. E-filing has been a requirement since
It is e-filed.
2014.
It has been e-filed.
Do you have an envelope number? So there's,
Does he have a copy that's clock stamped? I can take it.
right, or a copy that's been stamped?
I do have a
E-file-
file stamp copy.
You do?
Yes.
Okay.
Email it to C court too.
Could you email that to C court? That's that letter C
Mhm.
and then the word court,
Yes.
the number 2
Mhm.
at bear.org.
Yes, I'll do that right now.
Okay.
All right, it's sent.
Is this one the share code?
Okay,
Yes,
alrighty, I believe so. Thank you.
sorry, we're looking for like motion to continue this.
Gotcha. Okay, so your document defense is entitled Motion for Permission to Travel, Continue cause, hold alcohol monitoring conditions in abeyance and allow for the removal of ignition interlock.
Yes.
Okay. Let us get on record on cause number 672-803, State of Texas versus Jared James Raymond. Parties, please approach and identify who's before the court, starting with the state.
Brett Bosis for the state.
Daniel Rodriguez on behalf of Mr. Raymond.
And I believe that we have a pretrial service officer here
Yes.
for this matter.
Yes, Officer Leslie Lopez from Pretrial Services, reporting officer for Jared Raymond.
Jared James Raymond, are you here?
Yes, Your Honor, I'm here.
Thank you. Let the court, let the record reflect that the defendant is in this court session regarding this matter. His hearing with his attorney, all parties are via Zoom, appearing via Zoom. Defense,
Yes.
you filed a motion. The motion was brought by you for a motion for. Please proceed with why we're here.
Your Honor, Mr. Raymond has been ordered to be deployed, and on August 24th, 2022.
Let me
What's that?
interrupt you. You filed a motion for permission to travel, continue cause, hold alcohol monitoring condition in abeyance, and allow for the removal of the ignition interlock. Is that why we're here?
Yes, Your Honor.
Please proceed.
Your Honor, the reason we're asking is because Mr. Raymond, I've attached an order from the Department of the Army directed to Mr. Raymond stating that he is ordered to report on August 24th, 2022, that he's going to be, I believe, sent to Kuwait.
Continue.
And because of that, Your Honor, his deployment, I believe, will last 1 year. And because of that, we're asking for the cause to be continued to allow him to finish his deployments. We're asking that the normal alcohol monitoring be held in abeyance since he will be out of the country. And we're also asking that the ignition interlock, that he be allowed to remove that since he won't be driving a personal vehicle and he won't be in the country to calibrate it as he's supposed to. I believe it's 3 times a day. And also the ignition interlock would still have to be paid for every month, which I want to say is about $280 a month. Over the course of the year will add up to quite a lot while he's deployed, Your Honor. So we're asking for those things to be essentially held in abeyance while he is deployed.
Okay. State.
Well, Judge, since,
State, while you're formulating your thoughts, may I ask some questions, please?
yes, of course, Judge.
Okay. Counsel, when was the deployment orders? Became aware of the deployment orders, the date of the deployment orders?
The deployment order, which is attached, which should be attached to the motion and order, states a date of June 23rd, 2022.
When was this motion that we're hearing filed?
On July 20th, 2022.
Was there a reason for some delay?
Not that I'm aware of, Your Honor. I want to say that we were communicated with by Mr. Raymond maybe a week ago or maybe 2 weeks ago, and we have filed the motion 2 days ago.
Okay. State? And when was this I'm sorry, before I call State again, I apologize. What's the status of this case?
It's set for a trial announcement on September 8th, I believe. September 8th.
The court file indicates here that this is a October 2021 case. Offense date, a pretrial conference hearing was held on the 6th of June, 2022. And on record, this matter was set for a trial announcement on 21 July, 2022 for a trial date starting the 25th of July, 2022.
Your Honor, that may be so, but the last time I looked at the county website, for some reason that July 21 and 25th date don't appear, and the date of September 8th appears. I don't know how it was removed from that July 21st date, but July 21st was yesterday. And we didn't receive any notice of appearance to be in court. In fact, if you look at the county website right now, it's showing a September 8th pretrial conference set by Zoom. And that wasn't anything that we requested or asked for. It's just what county website is showing right now.
All right, the court file is there is a record as far as judges' notes in here, I believe, with those dates on there, where a pretrial conference hearing was held. And you were the attorney of record.
Yes.
And those are the dates, the trial announcement date that you made with, and I believe that was the state representative was ADA Lynn Han Martinez.
I remember that.
Okay. Now state.
Judge, the state would just, as far as defense's motion goes and the orders to deploy, the state's not gonna take a position either in opposition or in agreement with the motion. We would just leave it up to the court's discretion to decide what to do.
Pretrial Officer Lopez, has there been any violations of pretrial requirements in this case, pretrial condition? Or yes, bond conditions?
Yes, we did submit a violation back in January for an alcohol detection, but that's already been addressed. But since, and we had a hearing, I believe that was set back in April, if I'm not mistaken, to discuss that. But since then, we have not submitted another violation.
Very good. Counsel, do you have anything further on this matter?
No, Your Honor.
Motion is denied. We can go ahead and have a trial on this matter beginning the first week of August. We can have on the first of August. We can go ahead and do a trial announcement and be ready for trial, have a trial on the 2nd.
August 1st announcements, August 2nd trial.
Yes, sir. Yes, sir.
Okay, are we excused until then?
Yes,
All right, thank you, Your Honor.
thank you.
Go ahead and log off, Jared. I'll call you.
May I be excused, Judge?
Yes, Officer Lopez, thank you.
Thank you.
And Judge, do you need the state any longer?
As states, I have a matter that is I have a matter that is with Mr. Rojas, Attorney Rojas on Moss. I believe you conferred with him yesterday, and he was recalled for today. State, if you would make yourself available, I will call you if Mr. if Attorney Rojas shows up.
Okay, Judge, is that for a pretrial conference hearing or?
Yes, sir.
Okay. All right, Judge, yes, I'll be in the background.
All righty, thank you.
Mhm.
Let's get on record on cause number 2021 CV 04490. And this is the matter of 1603 Babcock LLC versus plaintiff versus defendant and Iwebe Holland, also known as Ann, Eno Holland. Parties, please approach and identify who's before the court, starting with the plaintiff.
May it please the court, Louis LaLauren for plaintiff 1603 Babcock LLC. We are ready to proceed on our motion for summary judgment.
Ms. Holland? Yes. Defense? You need to announce.
My name is Ann Holland.
You're the defendant in this case?
Yes,
Are you ready to proceed on this, on the summary judgment? The plaintiff summary judgment?
yes, ma'am.
Alrighty. Counsel, your motion, please proceed.
Your Honor, this is a motion brought under Rule 166A of the Texas Rules of Civil Procedure, paragraph C. We have submitted a motion for summary judgment to which is attached a number of exhibits, including Exhibit A1, which is a lease agreement. The lease, by its terms, began on August 16th, 2016, and was over expiration date of November 30, 2021. And I'll refer the court to the 10th page of the motion, which is also the third page of the lease that sets out the beginning and ending date of the lease. As established by the affidavit of my client, the defendant moved out of the premises at the end of March of 2021. The defendant is a guarantor under the lease. That guarantee agreement appears as page 49 through 51 of Exhibit A. It's also separately marked as Exhibit A-1 in my motion. Under the terms of that guarantee agreement, Ms. Holland is the guarantor for the lessee under the lease, which is an entity known as Malfu Home Healthcare Services, Inc. The sum that is due as damages suffered by my client as a result of the defendant's early termination of the lease appear as Exhibit B-1 to the affidavit submitted by my client. And it establishes that the damages are the sum of $12,216. Also attached to the motion as Exhibit C is my affidavit as the plaintiff's attorney, setting forth a number of factors why attorney's fees are due and that the amount that should be awarded by the court is $4,000. Also attached as the final exhibit, which is Exhibit 1 to my declaration, is a copy of the demand letter made on Ms. Holland, May 23rd, 2022, setting out the damages and totaling $17,664.66. Under the Texas Rules of Procedure, there is no oral testimony to be taken at this hearing. There has been no response to the motion filed. There are no contravening affidavits on file. And so there is no genuine issue as to material fact existing in this case before the court today. And we would move into evidence the exhibits A and B, together with all of their attachments. And we would ask the court to grant judgment in this case. And we have submitted a form of judgment that has been accepted by the clerk's office.
Ms. Holland, are you in receipt of the summary judgment?
Some of the things that I hear is not true. The lease, my lease was supposed to be out by the end of August.
Your Honor, I'm going to object to any oral testimony from the defendant.
Yeah, I have the lease. I
this-
can bring you the old list. I don't know where
This is a
my
summary judgment.
landlord. Yeah,
Understand, I'm just trying to ascertain, because I had not heard whether the summary judgment was served and properly, if you have receipt.
We do.
Was that- Was it served and proper receipt?
Yes, Your Honor.
yes.
Where is that, sir?
The receipt is not on file, however, I do have it. And the defendant is here pursuant to the fiat, which was included in the motion for summary judgment. I don't believe she's contesting receipt of the motion. And if I
That's
may,
what I was trying to ascertain, counsel.
I understand.
Because I do not have a copy of it, of receipt of the summary judgment.
Well, they're not normally filed, Your Honor.
Say again?
They're not normally filed, the returners, the receipts. However, if I may, just a moment, locate.
excuse me, Rana. What the, my landlord put here that the rent is $1,527. That is not true. My rent was
Your Honor, I need to object.
$1,530. So wherever he has this figure, everything did not match. I have evidence of all the all the bills that, all the checks that I've been paying this rent.
Your Honor, I will
And,
object to this.
and I have
testimony.
my list, all these things they have here is not true. And
Ma'am?
because of COVID, that was the reason I moved out. There was no business, there was no COVID. I moved out 4 months early. That's what I know. But now he extended it to December. That's not what my list said.
Ma'am, when somebody else on the other side says objection, you need to go ahead and stop talking so I can.
Oh,
rule
okay,
on
I'm sorry.
Objection. It's okay. That's all right. I just wanted to let you know that he said he objected to you continuing to talk.
Oh, I don't
Okay.
know those laws.
So, ma'am, this is the summary judgment document. Did you receive that?
Yes,
Okay. Did you hear what the attorney has said regarding no oral testimony, is saying that there's no genuine issues of, say that again, counsel, I don't want to misquote.
There are
you.
no genuine issues of material fact in this case, Judge, based on the summary judgment evidence, which what's
Yeah.
before the court today is my motion together with my client's affidavit and my declaration. The defendant has not filed any response to the motion and has not filed any affidavits and has not filed any declarations. So what is before the court today entitles me to receive a summary judgment.
Do you understand that?
no, I don't.
Okay, regarding the attorney's fees, counsel,
Yes, Your Honor.
did you want to testify to that or?
That's been submitted by declaration, Your Honor, which is attached as exhibit, it's page number 57 of the filing, and it's exhibit C to the motion for summary judgment.
Would you like to be sworn in? Please raise-
I'll be happy to, Your Honor.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth under pains and penalties of perjury, so help you God?
Yes,
I do, Your Honor.
All righty. Go ahead, counsel, proceed regarding your declaration on attorney's fees.
Yes, Your Honor. I have submitted to the court a declaration in support of an award of attorney's fees in this case as a matter of contract and according to the terms of the lease. The plaintiff is entitled to receive its attorney's fees. And my records total up to $4,000 being due and owing under the Texas Civil Practice and Remedies Code, section 132.001. I have submitted a declaration supporting those attorney's fees, which I believe to be adequate under the law. And we would request the court to make the award as requested. If Ms. Holland appeals this case, we would request an additional $10,000 attorney's fees on appeal to the Court of Appeals. And we would request that as a contingent award. I would further state that that's a reasonable and necessary sum for my client based on attorney's fees charged in Bexar County, Texas for similar services by members of the bar in Bexar County, Texas. I've been practicing for in excess of 40 years, and I'm familiar with the customs and practices of attorneys pursuing this kind of litigation in Bexar County, Texas.
You said that your declaration is at Exhibit C.
Yes, let me make sure you're on it. Yes, Your Honor, it is Exhibit C to the motion. It is page 57 of the motion.
Counsel, I thought I saw it. And you say that you do have proof of mailing this of service of the summary judgment?
Yes, Your Honor, and the defendant has admitted receiving it, and she is here today. And it admitted on the record.
Okay, I think I'm getting warm. Any, Counsel, I will take, excuse me, Ms. Holland, anything further?
I would like to ask to get an attorney because I didn't know that there are a lot of this stuff that they put here is not right. I don't know if there is time for me to do that because I don't have no lawyer and by myself, but everything that they put here is not right on this paper.
Your Honor, may I, in response, in the answer,
Yeah.
in the answer,
Because the response is not, he's suing me for $70,000. What I do, because of the name, that's what they think, like it's home health agency. I'm taking care of mental health and mental retardation children. It's not money. All what they're looking, they see the name home health, they thought like I'm operating home health. It's not like that. And because of COVID, that's why I move out of the property.
Okay.
And everything
Ma'am?
here is not right. I need to get a lawyer. If there's time for me, Your Honor.
Counsel, your response, the plaintiff?
Your Honor, in her answer, a copy of which she did not serve on me, but I obtained from the clerk's office, she says that she will obtain a lawyer. That answer was filed months ago. And she's had ample opportunity to get a lawyer. She had ample opportunity to get a lawyer after the filing and service of the motion. It's been more than 30 days. We have proved our case under the summary judgment rules.
The lawyer that I got, I'm from Houston, they said they can't come to San Antonio. I have to get a lawyer in San Antonio. Most of the people that I know, they're in Houston. They cannot come over here. So I'm going to look for somebody here in San Antonio. So if they give me time.
Counsel, did you hear the defendant? I believe they stated that they attempted to get an attorney, but in Houston?
Yes, and they say they can't come here. It's a different county.
Well, Your Honor, lawyers are admitted statewide, and Zoom proceedings are very easy to conduct from a remote location, and electronic filing means you can file documents in any and every county, which I do all the time. I don't think that's a valid excuse. Plus, she's had plenty of time since the filing of the answer and the filing of the motion to secure counsel. I just don't see what additional delay is going to do other than increase the amount of interest that she owes.
Counsel, you mentioned an answer that was provided through the clerk.
Yes, Your Honor. Apparently, Ms. Holland mailed an answer in. It is reflected on the docket sheet, but I don't have an electronic copy of it.
Uh,
And she just filed a general denial. She said she would just disclose documents that I have not received. And she said she wanted to get a lawyer. Well, she has not. She's had ample time.
okay. Oh. Okay, counsel. Counsel, anything else on this matter?
No, Your Honor. The plaintiff rests.
Don't. Counsel, I'm still flipping. This is a bit daunting. I'm still flipping to go ahead and see about that. Allow me the opportunity to be able to go to look through a very generous amount of paperwork and to be able to review everything. And do I have your phone number, counsel? I believe I do, but let
Yes,
me
Your
go
Honor.
ahead and let me get your phone, a phone number where I'll be able to reach you. I believe your contact information is on file here.
It is on file. It's on every pleading and then, yes, Your Honor.
All right.
I'll be happy to
Not a
give it to
problem.
you.
Not a problem. I will go ahead and get and obtain that from here. I've made some markings, but give me an opportunity to go through these as I just got these documents
I understand.
after, right. I've got the files and I'll take your arguments into consideration as well as your arguments, Ms. Holland. I've heard what you said. You said you need an attorney. And I don't see the and I need to check with the clerk regarding the that answer. I don't see it immediately. I wish I could get my hands on it, but I don't see it immediately so that I may be able to examine it, okay?
Yes.
The attorney says that you mailed an answer, so I need to go ahead and take a look at that. Alrighty, so I'll just need your contact information, ma'am. You can go ahead and provide it here, or if you have it on a document, provide it. That would be your email address and telephone number. And I will email you and Attorney LaLauren at the same time, okay? I'll communicate. I do thank you for your patience and your time regarding this matter. A late start.
It's fine, Your Honor. We're all doing the best we can under very difficult circumstances.
Mhm. Okay, very good. Alrighty. Okay. No, we want to look at it again? Thank you. Alrighty. Council and Ms. Holland, I will try to get to this document. I do want to let you know, I'm scheduled to be out of town the next week, the following week. So you may be hearing from me either Friday next week or the following Monday, okay?
That's fine, Your Honor.
Yes, Your Honor.
All righty.
And Your
Any
Honor,
date,
one further matter, we did upload a proposed judgment, so it's in the clerk's file.
Okay.
May
You
we be
loaded,
excused?
I'm sorry, you loaded up what?
We uploaded a proposed judgment to the clerk's file, which has been received.
Okay, a proposed judgment?
Yes.
That was filed on the 8th of July?
Yes, sir.
Okay, alrighty. I believe I'm looking at it. Alrighty, thank you, Council. I
May we
will.
be excused, Your Honor?
Yes, please, thank you.
Thank you, Your Honor.
Do I have your contact information? Okay, I do. All right, ma'am, you'll be hearing from me again in about a week.
thank you very much.
Hey. Okay, good afternoon, Attorney Ornelas, how are you?
I'm good, Your Honor. How are you?
Fine, thank you for your flexibility on this matter. I do have one short criminal matter I need to go ahead and attend to right now, so allow me to do that and then I'll be right with you.
Yes, Your Honor.
Okay. Alrighty, we're going to take up the matter of cause number 666511. Attorney Rocha, I see that you're here. Thank you for popping back in. And ADA Bosis. Let me try to reach him. I deal both Attorney Rocha, I'll wait for you to get a jacket on. I've just texted Mr. ADA Bosis to see if he's available.
I'm sorry, Your Honor. You're asking me to put on a coat?
A jacket, yes, sir. You're in court session.
This is not, okay.
ADA Bosis should be here.
Your Honor, is this acceptable?
That is definitely courtroom attire, sir. Thank you.
Great, thank you, Your Honor.
Okay. Excuse me 2 seconds. Let me. Attorney Bosis? ADA Bosis?
Yes, Judge.
Ah, there you are. Okay. Alrighty, do you have cause number 666-511 pulled up?
Just one moment.
Okay.
Yes, I have that pulled up now, Judge.
Ready. Alrighty, Attorney Rocha?
Yes, Your Honor.
Alrighty, okay, we got all the. All right, let's get on record on cause number 666511, State of Texas, excuse me, State of Texas versus DeMarcus Enrique Moss. Attorneys and attorneys only, please approach and identify who's before the court, starting with the state.
Brett Bosis for the state.
Jose Rocha for the Marcus Brown. Mas.
Alrighty. I believe this matter, as we're here for pretrial conference hearing today, the 22nd of July 2022. This matter was recalled and continued from yesterday, the 21st of July 2022, in which I believe ADA Bosis, you were representing the state, and Attorney Rocha was present as well. And we got on record. And at the time, we got on record and believe discovered that both the state and defense had not conferred on this matter. When the court asked of the state was providing whether or not an offer was had been conveyed. And defense, you had not had an opportunity to convey an offer to your client, and because you had not conferred with the state and gotten an offer. And so we're here because you needed to convey that offer to your client. And so we shall proceed from here. State, you said this was a San Antonio Police Department case so far?
Yes, Judge.
Okay.
Your Honor,
please
if I
continue.
may, I need to correct the record.
Oh,
So,
please proceed.
That was not the case. I was
Oh,
here
okay.
and I was here on numerous other occasions. However, I had stated, like I stated today and I stated yesterday, that I had no contact with my client, that I didn't know where my client was at. That's what ended up happening yesterday, and you asked me to come back today. In addition to that, Your Honor, I would like to make sure that the state is also in complete and fully dressed to address the court, just as you're requiring the defense to do so at this time.
State?
I don't follow, Judge.
I don't either.
But let me be more clear. I do not see that Mr. Bosis is wearing a tie or a jacket. I want to make sure that if you're requesting that from the defense, that the state is also dressed properly to be in the courtroom.
State?
I'm wearing a jacket right now, Judge. However, I don't have a tie on, so I can put that on right now, if that will satisfy the defense and the court.
Yeah, absolutely. I will wait here.
Judge, I have my tie on now, and hopefully we can get through this PTC since we've been waiting a long time for defense to arrive and take care of it.
Again, I will correct the record. I did arrive and I was told that I needed to be wearing a mask in your courtroom. So I stepped out because I had 6 other hearings to go to. So I did show up at 9 a.m., Your Honor.
You mean 9:50, defense?
Whatever it may be, Your Honor. I had told the court the day prior that I had several settings in person at the courthouse, and I was not aware that I needed to be wearing a mask in your courtroom, and I was not going to be wearing a mask.
So, defense, also, you have represented to this court several times that you have been asking for a trial in this case, correct?
That is not correct, Your Honor.
Oh,
I
okay.
have said that I have been to this court and that I have represented to this court that I do not have contact with this particular client. And I was hoping that we were able to fix that yesterday so that we wouldn't be spending all of this time today talking about something that could have been resolved yesterday in the expense of taxpayer dollars.
And what is that, counsel?
Being here today, Your Honor.
What could have been resolved yesterday that's not being resolved today? Because
The
you
fact that
represented to
we
this
were
court.
already there. The court set the hearing for yesterday. He was not, my client was not there. And I had told this court that I had no contact with him.
But you stated that you wanted to set the matter for trial and has tried to set it
No,
for
Your
trial
Honor.
several times?
We,
No?
we stated that we wanted to set the matter for trial on the 2 cases that were set for trial yesterday. Those are the 2 cases that we were ready to go to trial. We had asked to go to trial and have been set for trial. On this particular matter, I have no contact with my client. I have no direction with my client. And as such, I cannot speak on behalf of my client because I have no direction from him. Not only that, but I do not have an offer from the district attorney's office. However, yesterday, he did send an email and send an offer in writing on this particular client.
Yesterday was the first time that you've conferred with the state on this matter, sir?
This is the first time that the state has extended an offer, Your Honor.
No, yesterday was the first time that you've conferred with the state on this matter.
No, Your Honor, this is
No?
the first time that the state has extended an offer.
Oh, okay. All righty. Okay. I believe you were appointed to this matter somewhere in February, sir. So are you stating that you have not been in touch with your client since March?
No, Your Honor. As I stated yesterday, we did have contact, but I have no recent contact with my client.
Right, since March.
I
You
do
had
not
Mark-
have any recent contact with my client, Your Honor.
Oh, okay. But you did confer with the state yesterday on this matter?
Yes, Your Honor. And Mr. Boses did send an email with an offer.
And you did state that you wish to dispose of this case by trial that you've asked for several times.
No, Your Honor. I
Okay,
do not have contact with my client, and nor did we have an offer. So I cannot discuss the options available to my client without an offer. As such, I could have not asked for a jury trial. However, if the court would like me to withdraw, I will happily withdraw.
okay. The matter was recalled, and again, Attorney Rocha, you feel free to correct my understanding is that yesterday, this matter was recalled because you indicated to the court that this matter was going to be disposed of by trial. So
No.
therefore, a pretrial.
No, Your
conference-
Honor. You
Sir-
recalled it yesterday
Okay.
because my client was not present. And I reminded the court that I did not have any contact with my client. And you said, Mr. Rocha, look for the client, give him a call and give him the offer, and we'll come back tomorrow. And I said, Your Honor, I do not have any contact with my client. That's why it was recalled.
Hmm. Okay. Well, it is a matter of record and we can be able to examine that. So because again, the reason why we're having the pretrial conference that again, we started yesterday was you're insisting that the matter be set for trial. And in this court, if it's set for trial, we have a pretrial conference hearing. And that's what this was recalled for, pretrial conference hearing.
No,
So
Your Honor.
if that's,
Two other
it was-
cases
it
were
was
set
reset.
for that, and those two cases were set for trial. This one got lumped up into those other cases.
oh, okay, the one was a trial announcement, that other case was a trial announcement, and the other one was set for pretrial conference hearing. This one was also reset for pretrial conference hearing. You approached on the 14th of July, 2022, and that it was reset for that. Just trying to make it convenient for you because you had other two cases set for the 21st.
That's
So
correct.
you agreed, you agreed to that, to be able to go ahead and move this case to then. And then, okay, so what we're going to do is give you an opportunity here to be able to
I'm sorry, Your Honor. I think that the district attorney is present.
Attorney Boses?
I'm right here, Judge.
Yes, yeah. So what we're going to do, counsel, is we're going to give you an opportunity for you to take action on this matter, since now you've conferred with the state and you have received an offer in writing from the state. And so we will be able to go ahead and allow you to take action on this matter. Just so that you know, for pretrial conference hearings, defendants are excused pursuant to the attorney's direction. If you want them present for the pretrial conference hearing, they're present. If they're not, they're not. And there is some reliance on you to make sure that they're aware of the next court date, which would usually be trial announcement or call docket, barring any motions that may be set for a hearing. And on that. So I'm going to put you in a breakout room now to be able to confer with, consult with my court coordinator regarding the next move on this, because this court was firmly under the impression that you were insisting on setting a trial, or have set this matter for trial, and had stated that you have been asking for a trial for quite some time, sir. So I'll let you go ahead and take care of that. And Attorney Boses, I appreciate you having ADA Boses. I do appreciate you being here and hanging out for the majority of the afternoon, waiting for this matter to be dealt with.
Thank you, Judge.
And so, yes, sir, I really appreciate your time. So with that, we will go ahead and get off record. And I will state, I think that takes care of any matters related to state that I may need the state on. Thank you again. Have a great weekend. And Attorney Rocha, I will go ahead and place you in a breakout room with the court coordinator, okay?
After I receive a date, Your Honor, may it be excused.
Absolutely, sir. Absolutely. Have a
Yeah.
great weekend, okay?
Thank you, Your Honor.
Do you have it? Can you move it? Have you moved in? Yes, Attorney Rocha. Mr. Coleman is here. Okay. Alrighty. Attorney Ornelas, please, there's a matter I need to discuss with you after this hearing on another issue, okay?
Yes, Your Honor.
Thank you. Let's proceed with this one first. Let us get on record on cause number 2022 CV 02161. State, excuse me, in the matter of, wait a minute. Oh, I apologize. I apologize. Wrong. Sorry, grab the wrong file. Sorry about that. Let us get on record on cause number 2022 CV 01671 in the matter of Panther Springs plaintiff versus Stephen Coleman defendant. Parties, please approach and identify who is before the court, starting with the plaintiff.
Amanda Ornelas, Your Honor, on behalf of the plaintiff, Panther Springs, and I'm joined today by my client's property manager, Karina Castillo.
Defendant,
Yes, Your Honor, Stephen Coleman. Right now I'm by myself. I had been trying to get a hold of an attorney and I'm still getting documentation gathered. So additionally, there's a witness to some discrimination about me being in this apartment. And I'm trying to get a hold of her right now. So if that's going to mess with the schedule or push her schedule for the court, we're asking for, I don't know, a week or two to finalize some of those details and logistics.
okay, right now I just needed for you to announce that you're here and you're the defendant, but we will get into that matter just as soon as I'm done ascertaining that, correct, sir?
Yes, I apologize.
It's okay, it's all right.
Soon as you get.
Hold on 2 seconds. Thank you for your patience. Okay, so both have announced. Counsel, we're here for what matter? Plaintiff?
Are you asking for the cause number, Your Honor?
No, we're here for what matter? What's the issue?
Your Honor, this is an appeal from an eviction from the Justice Court.
Okay. And so, Mr. Coleman, you appealed?
Yes, Your Honor.
Okay. All right, and Counsel, you are the one who served the fiat.
Yes, Your Honor. Our office was employed when Mr. Coleman filed his appeal. We didn't do the original eviction from the Justice Court, but we joined and then we gave him notice that we filed a notice of appearance and then also the fiat.
Okay. Okay. And so, Mr. Coleman, you're appealing from an eviction that occurred at JP level. Do you want to go ahead and tell the court what's going on?
Yes, so several things. My employer has a legal plan in which I can speak with attorneys. However, none were available and willing to take my case. And then additionally, I had several communications in order to pay the rent. And it was denied to the effect of not being able to slide a check through the mail slot because they shut the mail slot. And online payments, they stopped accepting my login at all. And additionally, the property manager and several other residents were aware and heard the property manager say, you need to move out or something to that effect, in an attempt to basically force me out of here. And in doing so, they made it impossible to pay rent. So I'm asking for a little bit more time so that I can get an attorney through my legal plan.
Thank you, Mr. Coleman. I'm sorry, say again, some more? Did you have anything further, Mr. Coleman?
No, Your Honor.
Okay, counsel, plaintiff?
Your Honor, if you'd like, I can put on my case right now, or if you want me just to respond to those statements.
Please proceed, plaintiff.
Yes, Your Honor. On February 25th, 2022, the Justice Court Precinct 3 of Bexar County awarded my client $3,580 in unpaid rent. Mr. Coleman appealed his eviction on March 1st, 2022 from the Justice Court. His rent amount is $1,195 per month. The eviction was filed on the basis of unpaid rent, of which now currently remains unpaid in the amount of $14,017.52.
How much did you say?
Currently, he owns, as of this date, $14,017.52.
Okay.
Mr. Coleman's lease term was from September 1st, 2020 to May 31st, 2021, which has now expired and has not been renewed. Additionally, Mr. Coleman has violated his lease by participating in criminal activity and disturbing his neighbors. This has resulted in the police making multiple visits to the property to address these situations. We are asking the court to dismiss Mr. Coleman's appeal and award plaintiff possession of the premises located at 16585 Blanco Road, apartment 901, San Antonio, Texas, 78232, and award plaintiff cost of court. We also ask the clerk of the court to issue a writ of possession after the expiration of 5 days from today's judgment. In regards to Mr. Coleman asking for more time to employ an attorney, this is Mr. Coleman's appeal. He has had months to obtain an attorney. If he felt that he needed to employ one, he has had plenty of time to do so. He has not responded to any notices that have been sent by my office to him by certified mail, and he is now attempting to delay this hearing, which would require a showing of good cause. He cannot show good cause because he has not done his diligence in handling his own appeal from the Justice Court. That is all, Your Honor.
He cannot show good cause. Please just repeat that last sentence. He cannot show good cause because what?
he has not done his due diligence in handling his own appeal from the Justice Court. He just appears today and says, I need more time, but has not made a showing to me or to this court why he should be awarded more time when he's done nothing for months. This was appealed March 1st of 2022.
You said something about the lease. What was the lease period from?
The lease period was from September 1st, 2020 to May 31st, 2021. He was not renewed and he is not vacated, and then he also just does not pay rent. His statements that he's been unable to pay rent are just untrue.
So the lease was not renewed as of 1 May 2021.
Yes, Your Honor. At that point, he became a month to month, which is what happens when your lease isn't renewed, but you continue to possess the property anyway. And so he was still charged rent, but it was not under his lease contract at that point.
Sure.
Your Honor,
Mr. Coleman, I'm going to call on you to respond. Just hang on 2 seconds. I just want to finish, get a couple of things from Attorney Ornelas. How much did you say the monthly amount was?
The monthly amount is $1,195, and that actually went up from his original lease term. So when his lease term ended, there's a portion of his contract in the lease that says when you become a month-to-month tenant, your lease increases by a certain percentage. And so that's the amount you'll see on the ledger.
And 25 February 2022 is the was the JP judgment, right?
Yes, Your Honor.
Okay. Yeah, yes, Mr. Coleman, you wanted to respond?
yes, Your Honor. If I can share my screen, there's an email that I have that will show the court that I was trying to pay, and I explained it to the property manager in January of the situation, and since would not allow me to pay via online or in person, in which there was a point in time she relayed the message that she was instructed not to allow me to pay. Additionally, the amount of $14,000 from February, so it was $3,000, and then they're doing $14,000. For some reason, the math doesn't quite work for me. So can you, I'm sorry to ask, the amount again total on the balance is 14,000 what?
Plaintiff?
It's $14,017.52. That's his complete balance. That's going to include all of the extermination fees, the trash, the rent. That is his whole balance. What is just rent is $10,560. And so all of these credits he's accruing throughout this appeals process. And to address what he's saying about the January rent, what's normal at the JP level is once an eviction is filed, you have to pay that rent to the JP court. You don't pay that to the apartment complex anymore. They can stop collecting rent once the eviction is filed so that they don't mess with the court's filings. And so that's probably why he sees that part for January, because that is when the eviction would have been filed if it was heard in February.
So they start paying upon filing the tenant would have to pay into the registry of the court?
Yes, Your Honor.
And you say just the rents alone is 10,000 what?
It's $10,560.
Is, so the eviction occurred on the 25th of February. And when was the appeal filed?
From my documents from the JP Court, Your Honor, it says filed March 1st, 2022.
And counsel plaintiff, I understand and hear what you have stated regarding the amount of time that has passed. But this is the first setting regarding this matter at the appellate level? Is it?
Oh, yes, Your Honor.
And I understand and appreciate the amount of time, but the defendant has asked for time to hire an attorney. Is that what I'm hearing, Mr. Coleman?
That is correct. And additionally, a bit of discovery now because of the statement of criminal activity. Yeah. I'm asking the court for more time, Your Honor.
Mm-hmm. Plaintiff, would it be, what kind of time are you looking for, Mr. Coleman?
2 weeks.
And in 2 weeks, you can obtain an attorney in 2 weeks.
Yes.
Okay. But you've been looking since March.
That is correct. But I was just informed that my legal plan will allow me to select my own attorney and be reimbursed rather than it being funded through the MetLife legal plan directly to an attorney.
Oh, you were not sure of the requirements of, you have some sort of an insurance?
That is correct, Your Honor.
It's a legal, it's an insurance through. Okay.
Through my employer.
Oh, okay. Response to a 2-week reset or rescheduling motion for continuance for the defendant to acquire an attorney.
Your Honor,
Counsel?
again, we asked to move forward simply because it is our position that the defendant is stalling. He's had plenty of time to obtain an attorney, so we asked the court to deny his motion for continuance.
Mr. Coleman, anything further on this matter?
Yes, I'm not stalling. I've been a resident here for 3 years or more. And I've had some other legal matters that have taken some of my attention, if you will, but now that those are mostly complete, I can definitely retain an attorney in order to finalize this matter.
Okay. Mhm.
And if there's any way that I can make payments, I would appreciate that in the next 2 weeks so that that bill is not as high.
Well, I think that did you hear that? Did you understand that you should have been making payments into the registry instead of trying to make it directly to the apartment? Do you understand what the registry is, sir?
Yeah. My understanding is that it's through a cash deposit. I paid the initial bond as Attorney Ornelas stated to me earlier. So
You appeal from the JP court. If you have questions on how to be able to do that, then perhaps you should go back to the JP court, Attorney Ornelas. Go back to JP court.
I'm not sure. I would recommend giving them a call, but I'm not sure exactly how that gets paid.
Right. So go back to the JP court, talk to the clerks there, and then talk to the clerks at the civil filing to see about the about payment into the registry. Did you write that down? Paying into the registry?
I did not, Your Honor. Okay.
Counsel, I have heard your argument, and I also have heard the argument of the defendant. In abundance caution, I'd like to be able to give him a 2-week reset to be able to acquire an attorney. Can we reset this for the 5th of August?
I'm open that day, Your Honor.
All righty. Let me go ahead and put you with the person who's in charge, my court coordinator, to go ahead and firm that up, okay?
Yes, Your Honor. I do have one more request for the court.
Please.
In the meantime, during this continuance period, we ask that the defendant refrain from going to the front office and trying to speak to the property manager because she feels unsafe. And so we asked in the meantime, if he wishes to speak to the apartment complex in any way, that he please contact me.
Mr. Coleman, did you hear that?
Yes, Your Honor, I did.
Okay, so if you wish for this for me to order this continuance, I'm also going to order you to anything dealing with this case, the apartment, anything of that nature. Since we're in litigation, you need to contact the attorney for the apartments. Do you understand?
Yes, Your Honor.
Do you have her phone number?
Yes, I've called her several times. I have it right here, 210. Yep.
Okay. All righty. So you understand to do that, right?
Yes.
Okay. Let me put you in with let me put you in with the court coordinator. Okay?
Thank you, Your Honor.
Okay.
Thank you very much. Thank you,
Thank
Ms.
you.
Castillo, for being here. Appreciate it.
Thank you, Judge.
Okay, we're off record. If you will go ahead and move them to in with Miss Luna, please. And that's counsel, did you need your client there?
If possible, I'd like her there just to make sure the time works for her as well.
Good point. If you move Attorney Ornelas and Castillo and Mr. Coleman in with Luna. And Attorney Ornelas, would you be kind enough to call the court afterwards?
Yes, Your Honor.
Thanks. You have the number, right?
You know, if you have it in front of you, I don't have it with me at this moment. I can look it
Sure.
up if you need me to, though.
No, not at all. 210-335-2573.
Got it. Thank you, Your Honor.
Thank you. Go ahead and move them. Okay. Miss Arenze? Chisholm Arenze?
Yes, Your Honor.
Alrighty, need video? Talk about your case. Well, no, she can join. You have her as okay, Miss Arenze. Let's see. All right, Mr. Renzi, I believe your cause number is the 2022 CV 02161.
Yes, it is.
I'm muted. Let's get on record on cause number 2022 CV 02161 in the matter of Chisholm Arinze plaintiff versus Rihanna Salazar defendant. Parties please approach and identify who's before the court, starting with the plaintiff.
Your Honor, this is Chiza Marinze. I'm the plaintiff in this case.
And you're pro se? In other words, you're representing yourself?
Yeah,
You're not an attorney, correct?
no, I'm not.
Alrighty. So, Miss Rihanna Salazar, is she? Okay. I don't see anybody in the waiting room. Ms. Arinze, was Ms. Salazar noticed of this hearing?
Yes, I did send it through certified mail and through regular mail. And I also tried contacting her also at about 11-ish and about 1-ish today, that I don't know if she blocked me, but it was just not ringing.
It was not what?
It wasn't ringing whenever I tried contacting her. I think her cell, I don't know if she blocked me or anything, but it just wasn't, it would show like it was trying to connect and all of a sudden just stopped connecting.
Oh, okay. And what number were you trying to contact her at?
210-273-0457. I've always contacted her via that phone number, and she usually picks up, but she's no longer picking up.
Okay, all right, so this time that I asked you to come back at 1:15, I guess you checked back in around about 1:30. Did you call her?
I did call her at that time again. Yeah, and that was why it was showing me. Whenever it showed like it was connecting, but all of a sudden it stopped connecting. And I did try her about 8 times. And at those occasions, it was the same result.
Alrighty, thank you. Go ahead and proceed.
I'm finding this case on Miss Rihanna Salazar. I filed an eviction case on.
You need to, for us to be able to hear you better, you need to lower the volume or back up from your device a little bit. We can see you, but it's hard to hear you because you're so close to the device. Okay.
Can you hear me better?
Yes, it's just clearer. We could hear you, but it was just clearer. Please proceed.
Okay. I did file a case, an eviction case on the 4th of May. I did go for an eviction on the 4th of May, in 2022, this year. And the judge did rule in my favor and then the defendant went on to appeal the case. Whenever she appealed the case, I went into the court to go file the case, and I did send the mail to her. But I still haven't got any response. It did show that she received it via certified mail, but I never got any response back from her. The defendant hasn't paid rent since November 2021. And she stated that it was because of COVID. That later on told me that she did get a job and she was gonna pay the rent. And after that, she refused to pay the rent and said she lost the job again and then got another job. But pretty much I've gotten a lot of like excuses and inconsistent like excuses pretty much ever since I became a landlord. So that's the reason for my eviction notice. I do want to add right here, Your Honor, that the defendant already left the property. When I went to the property on Monday, on the 18th, I think. Yeah, I went down to the property on the 18th and I did see that she did leave the property, but she left it in shambles and pretty much took a lot of stuff out from the property and also left a lot of mess and broke a lot of stuff. So I did show proof of that. I submitted proof of that to the court yesterday.
All right. Ma'am, since there is an appeal, and the defendant is not here, you kind of need to tell the story of what happened, what has been happening. What do you want me to do?
Yes. So that's what I was saying. She hasn't paid rent since December of 2021. She didn't pay rent since
December or November, did you say?
So I took over the property in December of 2021, but prior to that, she didn't pay rent since November. So I'm gonna claim, yeah. So I didn't know if to claim from November or to claim from December since that's whenever I took over the property. But yeah, she hasn't paid rent since then. And she didn't pay rent. And from whenever I took over the property in December, she did inform me that she was going to, it was because of COVID and she got let go on her job and she was going to like start working again. She got a new job in January. She was going to pay me for the month of February, like pay me back for the month of December, January, and February. And we did agree on that. Then later on, she came back and stated that she got the job and then she got fired again. And so she couldn't pay me. And so I told her, I did give her notice to vacate the property in March. We did have a court date in April, which I could not make that court date because I was working on that day. However, I did go on again to file again for an eviction. And then we both showed up on that day, which is going to be on the 5th of May. The judge did rule in my favor and asked her to evict my property. However, she did appeal. She appealed the case, and that's the reason why I'm here today. But come to find out, I found out earlier this week on the 18th, that she already left the property. That whenever she left the property, she left a bunch of her stuff in the property, and she left the water running, which the water bill is under my name. She left the water running in both bathrooms and also in the kitchen. And she also left a lot of like dog poop and pretty much the refrigerator was filled with gnats, and she had a lot of like stuff and personal stuff in the home. I did take pictures of those and I did present it to the court. That so she already vacated the property, but right now I'm just trying to see if there's any way I can get reimbursed for all the damages that she caused.
Reimbursed. So you said you took over the property in December. What does that mean?
Yeah, I took over the property in December. She had a different landlord and I did purchase the property. Yeah.
Oh, you purchased the property in December?
Yes.
Okay. Okay. So you began owning the property in December?
Yes.
Okay, so you're looking to recover from the time that you owned the property?
Yes.
Okay, so what are you asking the court to do today?
I'm asking the court to get reimbursed for the time she didn't pay and also to get reimbursed for the
You're
damages that she
reimbursed for what?
To get the payment for the rent that she did not pay, the unpaid rent for those months, and also for me to get
What months?
so if I can get from January, February, March to this month, or from December, whichever, at least for 6 months. That's what I'm looking forward to.
From January 2022 to when?
To the month of July.
Okay, you purchased the property in December. Did you establish a lease with her when you purchased the property?
No, she had the old lease from the from the previous landlord, and her lease term, a lease end date was supposed to be in March.
Her lease was supposed to end in March?
Yes, Your Honor. But however, she didn't leave the property up until this month.
I'm sorry, say again?
However, she didn't vacate the property up until July.
Okay, that was the old property owner. Your damages started when, in December, when you bought the property. Did you have a lease, establish a lease with her then?
No, I didn't have a lease established with her. So I went by, whenever I purchased the property, I went by the lease that was already incurred with with the previous landlord, and I just went by the lease. But whenever the lease term ended, I didn't want to renew a lease with her, and I did inform her about that. At that time, also, I already given a notice to vacate, but she refused to vacate the property.
And the lease ended when?
In March 30th.
March 3rd, 2022?
Yes, ma'am. I'm just gonna check it again.
Did you notify her that you were the new landlord and that
Yes,
she needed to be paying you rent?
Yes, I did notify all the tenants in December of 2021. So we've been communicating since December of 2021, and I did notify everybody about the fact that I purchased the property. I did give them my information and give them everything. So she was very aware that I was the landlord, and she's been communicating with me since.
And how was she made aware of that?
I did come in and I spoke with her, and I also called her. So yeah, we've been communicating through cell, and that's how she's been communicating with me and telling me pretty much the progress with her getting a job and her losing her job and everything.
Was all of that communication reduced to a writing? When was that put in writing? All that communication you've been doing with her?
I've been communicating with her via text messages, that whenever our lease ended, I did however give her like a notice to vacate in person, and that was in March. That was the first notice to vacate. So that was in writing, and I did give her that in person.
Okay, so you're asking the court for unpaid rent from January through July, you said, in the amount of how much?
Your Honor? Sorry.
It's an amount of how much?
It's going to be in the amount of $6,985.
What is it?
$6,985.
What's the monthly amount?
The monthly amount is $995.
Is what?
$995.
Anything else?
And also for the damages that she caused the property.
Damages, how much?
The damages is going to be 10 grand.
I'm sorry, say again?
The damages is going to be $10,000. She did
How much?
leave the water, $10,000, Your Honor.
10,000, okay.
Yeah.
Okay. Anything else?
No, Your Honor.
Did you file a document with the court, the clerk, listing all of these things?
Listing the damages, Your Honor?
Yes, going ahead and saying, okay, this is what I want the court to do. You know, did you file a lawsuit, a counter on this,
No, I did not, Your Honor.
on her eviction appeal? She
Sorry, Your Honor, I
appealed to
didn't
the
hear what you
court.
said.
Remember you filed some documents and to evict her, right? To file a lawsuit in the JP court, correct? Do you recall doing that?
File a lawsuit?
Right, you filed a lawsuit against her to evict her, correct?
Yes, I did.
You remember doing that? And then she files, you said that was ruled in your favor, and then she filed an appeal. Okay, right. Did you file an answer to
For
her
the appeal?
Right.
She filed an appeal. So she filed the appeal and I went into the court and I scheduled the appeal to be for today. But I never
Sure.
did file an answer or anything.
You didn't file anything with the court yet? You didn't file anything?
No, nothing yet.
Right. Yeah, you sent,
Was I
you just went
supposed to
ahead
file
and then you just went ahead and sent in some documents and some pictures.
Yes, Your Honor.
Okay.
I retrieved those pictures whenever whenever I accessed the unit, whenever I came into the unit and I saw how much damage there was. So I decided to take those pictures and that's why I presented it to the court.
Okay, and then you're the one who filed a notice of a hearing.
Yes.
And that you sent that to her.
Yes, I did. And I have proof of that.
You have proof that you sent it to her by?
Certified mail.
Okay. Alrighty. So whenever you want the court to do something, you have to ask the court to do something. And usually you do that in writing. And once you do that writing, then you also need to have an order with that. That writing is called a motion. And then you can go ahead and do an order with that motion so the court can act on your request. Do you understand?
Yes.
Okay, so you can go to the fifth floor of the courthouse, or and then there's, I think, some staff attorneys over in the civil side to find out what you need to go ahead and do. Okay.
Okay, so Your Honor, at this point, are you talking about, do I need to file something else? Is that what you're saying?
Right, because the court has nothing to act on, has no paper. I don't have an order, I don't have any paper, no motion. I mean, I went ahead and heard, but I don't have anything to act on.
Okay.
Kind of hard to write in air. That's what you're asking me, that's why I'm asking you, did you file anything? Otherwise, I would have to write in the air. You want me to write something on paper, correct?
Yes, Your Honor.
Okay. So go to the fifth floor of the 100 De La Rosa and see if they will be able to go ahead and assist you with what you have to present to the court, okay?
Okay.
All righty, give you a couple of weeks to go ahead and get that straightened out. I'm going to put you in with my court coordinator so as to give you a date to come back once you have figured all that out, okay?
Okay, thank you.
All righty, thank you very much. We're off record on this matter. Let's see.